Stuart MacDonald.
Thank you, Madam Deputy Speaker. I'm afraid I regard this bill as a dreadful bill, and I think the Refugee Council was absolutely right to characterise it as the anti-refugee bill. There are 8 welcome clauses in this bill on nationality, but thereafter what we see risks trampling international convention after international convention. And vulnerable children, stateless children, the victims of trafficking will all pay a penalty. But nowhere is a retreat from international law and international cooperation and basic human decency more apparent than the absolute trashing of the Refugee Convention as it approaches its 70th birthday. A convention that has saved and protected countless millions of people being undermined by one of its first champion countries. Refugees and asylum seekers, and we've skirted over this so far, will be criminalised, will be stripped of their rights and offshored. And that is true whether or not they are Uyghurs fleeing atrocities in China, or Syrians fleeing war crimes, or persecuted Christians seeking refuge here. This bill does absolutely nothing to stop them getting in boats in France. What it does is punish them when they get there, and I think that is morally reprehensible. It's not just the awful ends of this bill that justify us refusing it a second reading and stopping it in its tracks, but it's the means by which it seeks to pursue those ends. What we're talking about here is a unilateral rewriting or reinterpretation of our obligations under international law. And that is, once more, a hugely dangerous precedent to set. And again, we'll make our international partners query whether this is a country that gives 2 hoots about international law and keeping its word. And secondly, to put it directly, what we have here is a deliberate policy decision to inflict harm on people seeking sanctuary, criminalising them, splitting people from their families, forcing them into destitution, putting them in legal limbo, offshoring them. So not just ineffective and dangerous, but morally outrageous. But not only is this bill the opposite of the right solution, it wrongly identifies the problem that needs solving. The problem in the asylum system is simply down to the incompetent management of it by this Home Office and this government. Madam Speaker, we live in a world where around 80 million people have been forcibly displaced. 30 million or so are outside their countries of origin and therefore refugees. 4 million are asylum seekers pursuing recognition as refugees. 86% of them are hosted in developing countries, 73% in neighbouring countries. What we're asking of wealthy Western countries barely scratches the surface of a share of responsibility. And in European terms, what has been asked of the UK is very little at all. Now, I absolutely applaud and I support everything that has been achieved through the Syrian Vulnerable Persons Resettlement Scheme and other resettlement programmes, but none of it justifies what the government is proposing today. Now, the government regularly trots out that it has resettled more than other European countries of the Syrian refugees, and in absolute terms that is absolutely true. But per head of population, neighbours such as Norway, Sweden, the Netherlands, the Swiss, the Finns and the Irish all resettled more. And yes, while the UK resettled a few thousand more Syrians in Germany and France, those two countries offered sanctuary to more Syrians through their asylum systems by massive margins. In 2019, the UK received around 5 applications for asylum per 10,000 people, compared to the European average of 14, putting the UK 17th in the table of member states, just behind Italy, Finland and Ireland. Similarly, the UK granted roughly 2 applications per 10,000 people, compared to the European average of 13, putting it 16th in the table. So yes, while by international standards the UK has a decent history of offering protection, let's not pretend it has been bearing an unbearable burden that entitles it to rip up the Refugee Convention and start trying to pass refugees back up the chain to those who already do much more. The real problem, as we've heard, is that the Home Office's handling of asylum cases is absolutely abysmal. We've heard about all the figures in relation to how long it is taking, absolutely extraordinary figures. And it's not just, of course, the length of time it takes to make a decision, but the number of decisions that it gets wrong. We're at record levels of successful appeals. It's almost 50-50. And it's not just statistics that cause grave concern, but the regular stories of life inside the Home Office, of impossible targets, of a culture of fear or ill treatment of staff, of high staff turnover and a shortage of skilled asylum caseworkers, and of administrative chaos. Asylum decision-making is a matter of life and death, and it seems clear to me that it should no longer be entrusted to the Home Office, a department which has again shown itself unfit for that purpose. It should be removed from political interference and entrusted to an independent body, as it is in Canada, and that would be a sensible approach. Madam Deputy Speaker, I don't absolutely democratic oversight as there is in Canada. But Madam Deputy Speaker, members of this House from all parties, and both front benches and back benches, regularly speak up for some of the most oppressed people on this planet. We have seen really brave interventions in the position of the Uyghurs fleeing atrocities in China. The plight of Syrians fleeing a decade-long conflict has been championed, and Christians around the world, including Christian converts, have numerous ambassadors in this chamber. But we've hardly come to terms with what this bill means for them. This bill prompts the question, Why speak up against their persecution abroad, only then, when they come knocking at our door seeking shelter, to say, "You're not our responsibility, go somewhere else"? France, as it seems to be the popular answer over there. What if France says the same thing in the whole of Europe? We end up with the whole system of international protection of refugees absolutely breaking down, as UNHCR point out. And if this bill passes, that is exactly what this means. Prior to this bill passing, we'd have sheltered these people if they fled here fleeing persecution. But this bill expressly seeks to discourage them from coming here by making life miserable for those who do. Today, if a Uyghur, a Syrian or persecuted Christian convert arrived in the UK to seek asylum, life would be far from plain sailing, precisely because of those outrageous waiting times and the dreadful asylum accommodation, the prohibition on work and the dreadful levels of financial support. But they would get there, and thanks to our amazing NGOs and charities, they would slowly start to rebuild their lives. But next year, if this bill were passed, for many of those Uyghurs, Syrians or persecuted Christian converts claiming asylum here, things will be infinitely bleaker, and that will be a deliberate policy choice of this Parliament. Arriving next year, the Uyghur, the Syrian or the persecuted Christian would be much more likely to be criminalised, and would be so criminalised regardless of arguments about whether they had come here directly or not. Just now, Section 24 of the Immigration Act punishes illegal entry by those without leave to enter, but sensibly those who claim asylum on arrival are granted immigration bail, which does not count officially as entry. But Clause 37 changes all that. It would essentially criminalise the very act of arriving to claim asylum because, as the explanatory notes acknowledge, the majority of asylum seekers will not have the ability to secure entry clearance. Despite her protestations last week, as the former Home Secretary has just said, this criminal offence will apply to Uyghurs or Syrians or persecuted Christian converts or anybody else, and the penalty is up to 4 years in prison. The next problem for the Uyghur, the Syrian or the persecuted Christian convert is that although they are absolutely obviously in need of international protection, this government, in its wisdom, isn't even going to consider their claim for protection for 6 months. Now, the government is trying to pretend this is some sort of replication of the Dublin regulations that the UK was party to prior to Brexit. But of course it isn't, because as we've heard, there are no returns agreements with any remotely relevant country, and there is little indication at this stage that there will be any time soon. Any such return agreement would have to be carefully circumscribed so as to be consistent with the Convention and carefully consider the circumstances of the individual, including any ties to the UK, such as family members here. In contrast, the powers in this bill allow the Home Secretary to remove a Uyghur, a persecuted Christian or a Syrian to any country at all, even if there is no connection and with very little by the way of restrictions. Today, the Uyghur, the Syrian or the persecuted Christian face outrageous delays in asylum protection systems. Instead, this bill simply adds another 6 months. And where will they be during this time, during this limbo, while the Home Office go through the futile motions of seeking to remove them? Just now, for those who seek asylum, we have a struggling, privatised, over-concentrated system of dispersed asylum accommodation. Numerous committees have told the Home Office how it could be improved, only to be ignored. But under this bill and this plan, that is not where the Home Secretary envisages the Syrian, the Uyghur or the Christian persecuted Christian going. Instead, the grim future for these refugees appears under this bill and this plan to be the disgraceful, disreputable, open prison-like conditions that we have already witnessed at Napier and Penally. Or even worse, as we've heard, they may face being removed to an offshore centre to have their claim resolved. And here is the real asylum shopping, the British government grubbing around to find a country to palm off its responsibilities onto. Think of the outrages and the lack of accountability that we have seen in relation to immigration detention and the Napier open prison, the abuses that have been meted out there and the harm done. And as you know from the Australian experiment, that will be as nothing compared to the hell that likely awaits from an offshore asylum facility. How on earth have we gone from a parliament where there was widespread support for time limiting and restricting use of detention to imposing a form of it that is infinitely worse? Having endured the limbo period, Madam Deputy Speaker, these three groups of refugees will finally have their case assessed by the Home Office. But instead of working to improve asylum decision-making, instead this bill seeks to make it harder for them to prove their case. It seeks to alter the long-established test set out in the Refugee Convention that the standard of proof required is a lower, but far from negligible standard of real risk. And that's a standard that is clearly justified by the possible consequences of getting it wrong and the huge challenges of proving circumstances that happened thousands of miles away in a country that the person has fled. This bill seeks to muddy the waters by applying a higher legal threshold. The claimant now has to prove on the balance of probabilities that they do belong to one of the protected convention groups and that they fear persecution based on that characteristic. That not only undermines the cautious approach in the Convention, justified by the dangers that exist for asylum seekers, but pays no regard to just how difficult it is to prove events that happened in faraway countries. And by having two different standards of evidence in the same proceedings, it makes life harder for already struggling caseworkers. The judge or the decision maker may be certain that the proselytising Christian convert will face a death penalty or torture on return. But now the real possibility that the claimant is such a proselytising Christian convert is not sufficient. If the judge is only 49% satisfied that the person is such a Christian convert, the claim is going to be rejected, even though the risk of torture or death is absolutely certain if the decision maker has got that assessment wrong. Madam Deputy Speaker, I find that deeply troubling, and it is clearly inconsistent with the Refugee Convention. But let's imagine the persecuted Christian, the Syrian and the Uyghur have survived their limbo period and they have made it through the asylum system, and the Home Office refusal of their application has been overturned on appeal. Unbelievably, the harms inflicted on them by this bill have barely started. On the contrary, the repugnant programme of disincentives is ramped up further even after they navigate that system. Because they've stopped temporarily in a European country, they are to be treated as a second-class refugee. And regardless of what any minister says, that is absolutely contrary to the Refugee Convention. And more importantly, it's just simply disgraceful, not just nasty, but sickening. Very briefly.
I thank my noble friend for giving way. Does he agree with me that on many occasions, particularly for those seeking asylum on the basis of their sexuality, that those in the LGBT+ community are the most likely to be adversely impacted by this new legislation? And does he agree that more should be done to protect them and ensure that they can come here as a safe haven?
Well, Fenn makes a good point, and there are all sorts of problems with provisions in this bill which penalise late disclosure of information, which can very often be the case in terms of modern slavery or LGBT cases, or even religious conversion cases. So having established that they are refugees, and the government has had to recognise that, the system should allow them to rebuild their lives after the trauma of their persecution, their journeys and their asylum claim, but instead this government still wants to turn the screw. Instead of the stability and permanent resident refugees were once provided with, today they are given 5 years leave with a review that is fairly light touch before settlement. But this bill and the government's plan propose endless 30-month cycles of review and ongoing attempts to remove. Nobody can rebuild their lives in those circumstances. I don't know how on earth the Home Office is going to cope with having to revisit every single asylum case every 30 months. These refugees will not be entitled to public funds unless they are destitute. So say the Christian convert finds some part-time, low-paid work, a big ask given language and cultural barriers and enforced years out of work and the trauma, but there will be no universal credit to cover housing or income shortfalls. And if he or she was able to bring a child, there will be no support for that child. And the refugee family reunion rights will be diminished according to the plan, meaning they can't be joined by a spouse or a child perhaps. The detail is not in this bill, but that is what the plan suggests and the bill enables. And that inevitably gives them a choice. Does the family stay apart, or do other family members, the women and the children that the Home Secretary professes to be protecting, then have to follow and to make their own dangerous journeys? Madam Deputy Speaker, without the family, without state support, without stability, there is no hope for the Uyghur or the Syrian or the persecuted Christian convert for rebuilding their lives. That does not amount to a place of sanctuary, it is a place of punishment, and the Home Office has the audacity to claim that this is in their best interest. This is, in short, an outrageous way to treat refugees, and that is why it has rightly been called the anti-refugee bill. Madam Deputy Speaker, there is so much that could be said about the undermining of efforts to support trafficking victims, the total absence of protections in this bill for children, the undermining of rights of stateless children. We need to know what the placeholder clauses will give rise to. We don't even have the chance to debate them here during second reading, and there are 6 or 7 of them. And the whole of dentistry, the dentistry profession, is up in arms at the suggestion that the discredited and unethical dental x-rays could return as an inaccurate method of assessing age. Well, that's what the dentistry profession says, and that's what the UNHCR say. It's not accurate and it is entirely unethical. She is making it harder to identify victims of modern slavery and cutting their recovery period to the minimum allowed in international law. And there is so much that should be in the bill that is not, and I mentioned just one thing. The failure to end the disgracefully painful 10-year route to settlement that many essentially British kids face, and the outrageous fees that others are charged for registering their entitlement to British citizenship. When will that finally be done? Madam Deputy Speaker, this is an abysmal and indeed a shameful bill. It does not remotely deserve a second reading.